Mr. Griffin, he stated that in order to avoid that miscarriage of justice, a recall or re-election will allow the student body to have their voices heard and to avoid a violation of the democratic process. And so through the specific enacted statute by the student body of 702E16, it was under the purview of the commission to order what it felt just to use its discretion as to not violate or as to avoid a miscarriage of justice.
Mr. Simon, what do you make of the stance that a recall election cannot exist if there has not been a final certification of the original election to begin with? What do you make of that argument?
Your Honor, if I understand your question correctly, you're asking what should be made of the argument that there hasn't necessarily been an election in this case.
Right, so how can you have a recall election at this point?
Your Honor, the student body has already voted. So I would contend that by voting and by overwhelmingly voting for the candidates of the United Party, there has been an election. But that election is null and void due to the United Party not following Section 714.3B of student statute. Therefore, that election is void. That the student body, however, through the recommendation of the commission, has yet another opportunity to exercise their rights to vote and vote for whoever they feel should uphold the candidate or the candidate.
Mr. Simon, you just referenced student body statute 714.3, and earlier you made reference to a final and statement singular. But if I am to read this correctly, final and statements, plural, shall be submitted to the supervisor of elections no later than 4 p.m. So if I were to read this plainly, final and statements speak to the fact that there are several statements that should be submitted. So what's to the argument that 3 of those final statements were submitted, and the only thing we're missing is 2 of those final statements plural?
Your Honor, I would categorically disagree with that position because in the plain reading.
So you would disagree that it says final and statements plural?
Your Honor, I would agree to the fact that the statute 714.3B describes what a final statement is, and it goes to say those final, the final extent statement shall include 5 specific documents. Qualification 5. In the qualification 5, it determines or requires nothing less than full and complete.
Counsel, I have an issue, and I really need an answer on this one. I don't understand how the remedy imposed by the election commission changes anything. I mean, the election commission is asking for a recall, but how does that change the will? How does that affect what the student body apparently wanted? You know, they won, the United Party won by overwhelming majority, so how will having a re-election change the fact that, you know, it just didn't turn into a piece of paper?
Your Honor, I'll refer you to the last page of the brief, in which this remedy in fact gives both parties an opportunity, both the Progression Coalition as well as the United Party. It gives the United Party an opportunity to redeem itself for violating Section 714.3B, and then it gives the United Party, it gives the United Party an opportunity to redeem itself, and then it gives the Progress Coalition an opportunity, or essentially a second bite at the apple, to have another election, and who knows what happens in that election. I'm not prophetic on it, but it does give both parties an opportunity, and using its discretion, the commission felt it was too harsh or
Mr. Simon, do you believe there's been substantial non-compliance in this case to prejudice any of the parties?
Substantial non-compliance, Your Honor. The statute does not talk about substantial non-compliance.
No, I'm asking you specifically. Do you think there's been substantial non-compliance to prejudice any of the parties?
Yes, Your Honor. The statute is very clear. You need 5 documents in order to have a final expense statement. They have 2 out of the 5. They're in 2 specific places. In the front of the final report, essentially for itself, it says which documents are required. And then which documents is required. And additionally, all parties must show orientation of some sort in which they know what they have to do. So with many opportunities to do what the election are, and yet still falling short of meeting those requirements, I feel that is the essence of what suspension non-compliance is in this case. Additionally, Your Honor, the opposing counsel mentioned Florida statute as of the issue of supremacy.
Counsel, I'm really having a hard time understanding this from you. I'm really having a hard time understanding, because you spoke about section 702 or chapter 702 E16 and how that allows the election commission to use their discretion to avoid a miscarriage of justice. But why couldn't the election commission issue a separate remedy, maybe one that isn't as taxing as having an entirely separate election?
The answer to that, Your Honor, is that any other remedy I would contend would be violating section 715.9, which said immediate. I would absolutely no qualifiers with absolutely no hesitation, immediate dismissal. So any other remedy would be a violation of section 715. In addition, Your Honor, the council talked about Florida laws, or Florida election laws. I wanted to clarify that student statute 718.1 says the court may look to any part of the election laws of the state of Florida not, and I emphasize the word not, in conflict with student body constitution and statute. In this case, this is in direct conflict with student body statutes, since statutes mandates that you do not turn in these specific requirements. If you don't turn in these 5 documents, if you don't turn in this final expense report, it's immediate dismissal. Whereas Florida statute mandates that you have some time, or it's considered a condition.
Counsel, you do recognize that it was an incomplete submission, not just a failure to submit the extension report.
Your Honor, the statute doesn't make this distinction.
Right, so since it doesn't make that distinction, why are we trying to go with the furthest end of the spectrum and, either disqualify or do a recall? Why couldn't there be a less severe penalty? Since there is a statute on point for incomplete submission.
Your Honor, I believe the logic is simple. Statute 714.3 states that you have to turn in the extension report, and it further explains what this extension report is. And then statute 715.9 states that if you do not comply with statute 714.3, then it's immediate disqualification. In fact, Your Honor, I would say the statute even goes as far as to say that no other penalty can be assessed for failure to submit a final expense report. No other penalty. So to come up with any other
Mr. Summers, then argument that you made that a final or an incomplete submission is completely different from failure.
Not in this situation, Your Honor. And I'll refer you back to my previous argument in which the Ignite Party had many opportunities to know what the rules of this election are. In fact, it's my understanding that they're the incumbent party, and so they're even previewed or have the benefit of knowing.
My question is, why is this a failure to submit as opposed to an incomplete submission?
One moment, Your Honor.
Section 702.2E16 you keep referring to, which allows for the Elections Commission to avoid the miscarriage of justice. That statute also speaks to the party in violation making a good faith effort to comply with the procedure which was violated. You're saying here that it was clear on the sheet that these 5 things needed to be there, and they weren't. So how is that acting in good faith? How did they act in good faith so as to give the Election Commission this discretion?